Duane Duggan, Remax of Boulder Podcast here. Today we have Jon Goodman from Frascona, Joyner, Goodman, and Greenstein again today. John, we appreciate you being here for all your wisdom that you offer.
Thanks for having me, Duane.
Listeners. So today we're going to talk about improper use of contingencies. One of the things that we've seen in our market today is possibly on a weekend, there's multiple offers on a property, a buyer ends up offering more than they think they should have on Monday morning, and on Monday morning they go, what did we do? We want out of the contract. So one of the things that happens is they might back out on inspection. What happens in that process when they've just changed their mind and then they use the inspection as an excuse to get out of the contract?
Well, right now the market's pretty hot, and most of the time when that happens right now, the seller is disappointed but has a good riddance mentality. Let's kill this deal now and move on. But not always. And while there's a lot of contingencies in contracts that let buyers out of the deal, generally there's not a contingency that says the buyer can back out for any reason at all or no reason at all up to a certain date. The buyer has to have a reason that fits the contingency. And if the seller doesn't feel the buyer is legitimately backing out using one of the contingencies in the contract, then the seller might engage a skirmish with that buyer.
Okay. Now, one of the things, this scenario that I described at the start there has actually happened in our office quite a bit, where people just change their mind on Monday morning. And one of the things in our industry that we see now is that all the offers are done online, on the computer, they're signed electronically and shipped off to the listing agent, with the earnest money check needing to be delivered within a certain number of days, usually maybe like 3 days down the road. So we've learned that some of the consumers think that just not tendering the earnest money is a way out. Is that true, or what happens in that case when they're trying to back out?
It's not legally true. The failure of a buyer to deliver the earnest money is a breach of the contract by the buyer that would allow the seller to sue that buyer for the earnest money. Now, as a practical matter, it often works, again, because the seller doesn't want to engage the battle. Life is short. The seller's thinking and the listing broker's thinking is, let's move on and find a better buyer. And so it often works, but it's not guaranteed to work, and it will work with less frequency at some point in time when the market slows down, because the seller will have anger that they weren't able to close with buyer number one, let's say at $500,000. That go out to the market, the next buyer is only willing to pay $470,000. The seller perceives they've been damaged by $30,000 by buyer number one, and that seller might be inclined to go after buyer number one for that earnest money.
Okay. I wanted to share or get your thoughts on another example, and that was like, let's say all the conditions of the contingencies of a contract have been removed and they're down to just the survey condition. They're waiting for that. And in that time, the buyers found another house that they would like to buy. So they want to back out on the survey condition. They get the survey, and let's say there's a 6-foot utility easement across the back of the property that the survey shows, which is extremely common. But the buyers decide to use that as an excuse because they say, I don't like that 6-foot easement, I want out. What happens in a case like that?
Well, Duane, who do I represent in that story, the seller or the buyer?
Well, let's go with the buyer in this case.
Of course, that's a legitimate out. So that is a kind of common skirmish that's engaged, and I think the buyer has the advantage. If the buyer does have a survey, if the buyer has gotten a new improvement location certificate, maybe even if the buyer is relying on an improvement location certificate supplied by the seller, it's pretty hard for a seller to argue that that is not a good faith exercise of that contingency. Now, sometimes there's facts of a given case where the buyer's agent has inadvertently forwarded an email from the buyer to the buyer's agent that says something like, even though I don't care about this utility easement, I'm just using this as an excuse to get out of the contract. That doesn't happen too often, but absent something like that, I think the buyer has the better argument.
And sure, I mean, there could be real reasons that it could be a problem, because let's say they were under the impression you could build a garage to the lot line like some areas of University Hill, and then they find out there's an easement there and they can't build on it. So
yes,
there's certainly reasons that they could back out. So
yes.
Hey, now, if a seller legitimately feels that somebody's misused a condition or a contingency in the contract, what's a seller to do?
The seller can exert a lot of leverage simply by refusing to sign an earnest money release form authorizing the return of the earnest money from whoever's holding the earnest money back to the buyer. Earnest money is most commonly held in Colorado, at least, by a neutral title company. Unless the seller authorizes the release of the earnest money back to the buyer, the title company will just freeze and not release the earnest money back to the buyer. Now, that's not necessarily fatal for the buyer. Another topic for another video about what the buyer does, but it ties up the earnest money for a long time. And then if the seller is inclined to be more proactive, for example, by filing a lawsuit, the seller has a battle on their hands.
Right. And it could be extended time-wise, too.
Yes.
So in terms of today's market, it might be just easier to put the property back on the market and work with the next buyer.
Different sellers react to that differently than you or I might. And so the buyer can't count on the seller acting rationally.
Right. Okay. John, anything else on this topic?
That's good enough for now.
Okay, John, thanks for being here and offering your wisdom. Always appreciate it.
Thank you, Duane.
Duane Duggan, RE/MAX Boulder Video Podcast, signing off.